Hello and welcome to Money Matters. My name is Busi Mbokazi and today we're discussing wills and estates. What are wills and estates? What does it mean to have an estate? And to help us work through these questions today, we are joined by Dr. Costa Sibanda from the Akato Group. Dr. Sibanda, welcome to Money Matters.
Thank you so much, Busi, for having me in the studio.
You're so welcome. What are last wills and testaments?
Right, a will or a testament is a document drafted by someone who is preparing for, obviously, for their death, that after their death, this is how their goods, their material, their property is going to be apportioned upon people that are left behind and are living.
Okay, so what are the legal requirements for a will to be deemed a will?
All right. For us to have a will, the first important thing is that the person should be above 18 years.
Okay.
And also the document has to have proof that it has been drafted by the person who is dead.
Okay.
And usually you should have a witness. And the witness should not be a person who has interest or a person who is going to gainfully get something from the property that is remaining or the estate.
Okay.
So, and at the same time, it has to be, the will has to be clear.
Okay.
And it has to show that the person meant what they were saying.
Okay.
Yeah, but to tell you the truth, it doesn't need to be a long document.
Okay.
In 1925, one of the wills that were written in UK, it was a one-line document which just said, after I die, this is how you apportion. And I think it's also recorded that there was one word, a will that was one word.
Oh.
Yes. Yes.
Simply
so, yes,
give it to
yes,
X,
as long
and
as
that was
it is proof, probably the handwriting,
yes,
that this is the person who wrote the document.
Yes.
And for probably issues such as proof and legal issues, some people even prefer to involve attorneys, lawyers, to authenticate that document.
So a will does not need to be drafted by an attorney or a legal person.
You can draft it, and any person can draft it.
Any person is able to draft a will.
Yes.
And it is deemed a will because it has been done by you, the person,
the first important
who
thing
owns
is,
the assets,
yes.
And who will want to leave them to certain people.
Certain people.
And would make very clear what those things are and
Yes.
to whom those things are left.
Beautiful.
And would state that how that you would deal with them going forward.
Beautiful.
And no further information is required apart from obviously
Signature.
identify your signature.
Yeah, that is important. This signature has to be also be able to be proven that it is for the person who passed away or who's dead. That it is the person who signed to say, yes, I'm apportioning these things this way.
So if someone drafts a will in South Africa and they pass away in England, does that will no longer have effect, or does the will continue to be of force and effect?
That is a very important question. When you draft a will, it's very important to consider the rules and regulations and legal implications of the country that you are in. Yes. If the will is drafted in South Africa, the law of South Africa is applicable.
Okay.
And the person traveling to UK does not then make the will void because it is going to be apportioned in South Africa.
Yes.
But then if the person will want, probably if the persons that are going to gain from the will are in England, then therefore this person can choose to make to do two things, multiple wills. And then this person will also have to draft a will in UK and draft a will in South Africa. And there should be proof enough that these documents were drafted by the same person. And usually, again, legal, when you draft a second will, it may make the first will null and void. You understand? So you have to be very careful in that instance that you make it clear that you are drafting this second will because of the people that you want to gain have relocated to UK. Yes.
So you would like for them to obtain benefit,
Yes,
even though
yes,
they
they are
are
beneficiaries.
outside
Yes.
of your country. So
Yes.
the beneficiaries, you had also mentioned that the beneficiary earlier cannot also be a witness
Yes.
on the will.
Yes.
Why is that? Is there any legal basis for that, or is it just to make the document as independent as possible?
It is possible that the person can act in bad faith.
Ah, okay.
Yes.
So it's
Yes.
possible that the person could influence
Yes.
the outcome
Yes.
of, or the
Yes.
drafting of
Yes.
the will itself.
Yes. Looking at probably also, maybe it's important for me to add that, remember, the will has to cover the spouse. The will has to cover the children. And wills, at times, they have to go as far as covering even the descendants, people like your grandchildren. So it is possible that by virtue of adulthood or by virtue of being a person of older age, the spouse may somehow push or alter the will to favor themselves, or it is possible even the adult child, whoever is older within the children, may, if he's involved in witnessing, or the uncle is involved, knowing that we are in Africa, in the African context, the roles of firstborns and even the wars or the retributions that are there between wives, surviving spouses, and firstborns in the issues of inheritance.
So I've drafted my will,
Yes.
and it's reflective in South Africa and in England,
Yes.
but now I change my mind for all these reasons that you pointed to. I
Yes.
don't know, I no longer get along with my child, I don't like my spouse, or I divorce my spouse. What happens? Am I able to just change my will? Is it as easy as changing my mind? What process do I go through to change my will?
What is important is that that is why we even talk of the last will.
Yes.
It says last will and testament.
Okay.
So what happens is the document that will be written last, for obvious reasons, becomes the most valid document,
Okay.
unless there is reference of the older document. Yes. Looking at it from the common law perspective, if a person decides to change their mind and they draft any document that is valid with all the requirements that we have mentioned thereof,
Yes.
then that document is, you don't need an attorney to then say this will is legal or not legal. But in an event where there is millions of friends that you're talking about, in an event that there's plenty of property that you are, then therefore it's advisable that you bring an attorney, property attorney, or an attorney that specializes in deceased estates.
What happens if I've drafted a will and maybe I've neglected to mention an estate, or maybe shares that, or not an estate but an asset, and maybe shares that I may hold in my name? What happens to those things that I've not specifically mentioned in my will?
If I hear you well, you are saying it's possible that I have a house in Cape Town, I forget to mention it in my
Yes.
will, and then I die, the will.
Yes.
Then that becomes part of government. It is then transferred to the government fund. There is a fund. Remember, we run wills and testaments under the Succession Act.
Yes.
So the Act, therefore, will protect the government to therefore use. You remember what happened with the Nobel Peace Prize? You know how it,
I'm not aware what
came
happened.
about, where the owner of the property or the monies and everything did not have anyone to give it to, then said this will be given to beneficiaries that are of, for example, peace. That is why Mandela had to win, because somebody was promoting peace. So government may decide, with obviously all the legislations considered, to then put it under a specific fund to help certain people, probably that for a reason that you stood for. If you're a person that was standing for people's rights, it may even go to such organizations. But that has to be done under the context of of the law.
If I may take you back a moment, there's the matter you've mentioned, the Succession Act.
Yes.
And I know that we then deal with testate and
Yes.
intestate succession.
Yes, yes, yes.
Can you just explain the difference between the two?
All right. In a case of someone who doesn't write a will, and the person just leaves property, leaves a lot of other things without it being covered, then that's when that comes in, where we say obviously the beneficiary is starting from the spouse, coming on to the children, if the person didn't have children, the grandchildren. If there are no grandchildren, we look for the closest people in their blood family and everything else. Yeah.
Okay, so that person is
the person who then is deemed the closest then becomes the beneficiary.
So a person who has a will is deemed to be testate or intestate?
All right, the person who has a will has intestate.
Is testate?
Yes. Yes.
So a person who has
yes.
a will is testate,
yes.
or has
yes.
then testate
yes.
succession
yes.
follows?
That's why they call that person the testator.
Okay.
Testator.
Yes.
Right. Yes.
And that means that then
yes.
succession will then follow in accordance with the will.
Yes. Yes.
And should there be any assets
yes.
which may have been neglected to have been included in the will, or because the will had not been updated for some time, what would happen to those assets? Would they then form part of the intestate succession of that deceased person, or would they then form part of this fund?
It's possible if we prove it beyond reasonable doubt
that it's his.
This belongs to the deceased person,
yes.
and that you have the legal right towards the property as a group. Because remember also there may be infighting within the beneficiaries. That is why I'm bringing in the issue that at the end of it all, that money or that property can end up being forfeited by the government.
Okay.
Yes.
I think that would be a good place for us to take a break.
Yes.
We'll be back right after this.
Yes.
Hello and welcome back to Money Matters. We're still talking to Dr. Sibanda about wills and estates. And we were just discussing, Dr. Sibanda, what happens and what's the difference between testate and intestate succession, the applicability of the Succession Act, and you've also advised us in terms of how it is that we can draft wills, that we don't need attorneys, we can do it ourselves. We just need to be clear, be very deliberate, and be, I suppose, again, make sure that our witness is not a member or someone who will benefit from the will, so as to avoid any mala fides, as the lawyers say. And so now I'd like us to touch onto the secondary part of wills and estates, which I think is the part that touches most people. It's when the person has died. So what happens once someone has passed away? With your will, we have heard words like executor and the master of the high court and all of these, and liquidation and distribution accounts and all of these very complex technical terms. Let's start at the beginning. What happens when someone passes away?
All right. When you pass away and you have written a will, usually that will not be an issue. Though yes, issues will arise again because of people being people. But where there's an executor having been appointed and a will has been drafted, then everything has to be done accordingly. But in a case that you referred to before we went to the break, where the person did not include their
a specific asset, yes.
A specific asset, probably you are saying a person owns shares in a multi-billion company, and then they happen to not include that. There are two issues that can happen with proven beneficiaries and with the will assigned. And if these two can be married together, that these shares, these billions, belong to this deceased person, yes, with the right legal procedures followed, it is possible that they may benefit the beneficiaries.
Okay.
But it is also possible that with a failure to prove beyond reasonable doubt that there is any relations, then government is to benefit, and usually organizations that are not of government purpose, that are non-governmental, will then benefit, especially that if they are in line with what you stood for. If you were someone who was standing for the rights of people, then certain organizations that are involved. I think you know of all these funds that are put up in foundations. Usually those they become beneficiaries of such.
I think the point that we might need to emphasize is that it's not so difficult nowadays to identify assets. Most assets are attributed either through an entity, which would have very clear shareholders and directors,
Yes.
or are put into the name of the person who's identified through ID number, passport number, etc.
Yes.
So I just want to try and reassure everyone at home that, you know, showing that this asset belonged to your deceased might require their ID, might require proof of your birth certificate to show that your relationship with that person.
Beautiful.
And that would all tie in together to help you basically bring the asset from being outside of the estate back into the estate,
Yes.
and then dealt with accordingly. That's if I'm hearing you correctly.
Yes, it's quite correct, but the other scenario that you brought in, it might be assets that are in a different domain, judicial domain,
Yes.
maybe country.
Yes, exactly.
Then that
of course, then
becomes
things start getting a bit
different-
tricky.
Yes, that's yes.
Okay, I
yes.
completely understand. So how is it that you go about appointing an executor of an estate?
It has to be done with the Master of High Court. It has to be somebody who he has the proven qualities to be the executor, and at the same time, it has to be done within the legal framework. And when I'm saying within the legal framework, that the person also should not have interest towards the estate. Yes. Yes.
So where would one find such a person? I mean, can you appoint a random person with these qualities, or would you have to appoint an attorney, or would you have to appoint someone in good standing, you know, on what measure? How do I find such a person?
An executor can be your wife.
Okay.
An executor can be your husband. An executor can be your firstborn child. In the African context, usually they would give it to the firstborn child, especially if it's a son. In the African context, they would give it to an uncle. Yes. But,
and the executor, what would their powers necessarily be? Or how would you be able to identify the executor?
Yes. The executor should be able to distribute the property fairly according to the will.
Okay,
or the testament.
And where there's no
Yes.
will, how would the
Yes.
executor be able to perform their
Right.
duties?
Then we are moving away from wills and testaments. We're talking
Yes.
about inheritance.
Yes.
Then we are looking at the issues of inheritance. When we look at the issues of inheritance, biblically or in the Christian world versus the African culture, there's some sort of intermarriage, there's some sort of similarities.
Okay.
Yeah, where you would find in the Jewish nation, it was very clear that the firstborn child will then have ownership of everything that remains. But when we are saying everything, you are saying do not forget your young brothers and your young sisters.
Your
So when you
responsibilities.
are owning everything, including your young sisters, including your mother, meaning that you are going to be able to distribute and use these things not for your own benefit or your family only. You are going to use for everybody's use, and it's the same thing with Africa in the African context, that the executor must be able to be somebody who then share and use the resources with the family, of the family, and that is key. And in a case where the person who is in heir, in this case, in place of the executor, when it's the will, an heir has to have interest of the whole family, and including the extended family. And it has to not only limit that to just a few individuals that are known thereof, it can even include your stepson, your stepdaughter, who was not within the surrounds when the deceased was alive. Yes.
It's my understanding that when an executor is appointed,
Yes.
that I'm assuming you'd obviously fill out some paperwork with the Master of the High Court to have this person be appointed, and they would receive this piece of paper, the certificate, or this proof that they now are in charge of the estate of the deceased person, so that they can start taking charge and taking care of the rest of the family. Usually, what has happened is that accounts would be frozen in the name of the deceased person.
We're talking about money now.
We're talking about it all.
Yes.
So, so what powers does the executor have? Kind of revisiting the conversation, not just only about inheritance, but now we're talking about the assets and including the monies. What powers does the executor have in terms of putting these affairs in order? Because it is my understanding that that's what the executor is trying to do, is to put the affairs of the deceased person in order.
Let me make it clear. The executor must be a person who has the interest of being very fair, of distributing the assets according to the instructions that are in the will or in the testament, number one.
Okay.
Number two, the executor per se will not limit it to only on the legal matters where the Master of High Court and the certificate is given. Remember, in the African context, back in Limpopo or outside Limpopo, in Swaziland or in Zimbabwe or in Malawi, they may not have that privilege of going to court. But is that not being done? The will is not being... does it mean then the will ceases to be a will because there's no Master of High Court when there's a paper written and there's proof enough?
I think the wills are quite easy. I think that's a simpler one.
Yes.
I'm more interested in us discussing the intestate succession, where
Okay.
there's no will,
There's
because
no will.
that is the general African context, if we are honest.
Yes.
Africans do not generally write or
We
draft
do not.
wills. So
Yes.
I'd like us to focus our conversation on the intestate succession.
Yes.
And then what is it that the executor in that situation, what are his powers and his responsibilities then in terms of bringing together the assets and ensuring that the creditors are taken care of, ensuring that the children's school fees are paid for,
Yes.
and ensuring that Ukoko, wherever she may be, is taken care of. What are the executor's powers and responsibilities in that respect?
Through common law, the executor has to meet the first of all, he has to gather the material and property. And obviously, one thing that you have mentioned, the issue of bank account. Once the person is deceased, the account is frozen. Right. When the account is frozen, it's not only for the deceased person that gets frozen, even for the spouse gets frozen.
If they're married in community of
yes,
property.
if they're married in community
Yes.
of property, then a new bank account is then what? Formed, which is mainly meant for distribution, right?
Okay.
Yes. And remember, you are not only acquiring money, let's be honest to people, you are even acquiring debt.
All the debt, yes,
Yeah,
of
understand.
the deceased
Yes,
person.
yes,
So how is
yes.
it that you then deal with that debt? It's my understanding that then the executor would be required to undertake a liquidation and distribution account, so where they would
Yes.
actually notify
Yes.
the deceased persons
Yes.
that they have passed on, that
Yes.
this person has passed
Yes.
on, and
Yes.
that this is how the monies will be then.
Yes.
And then what happens to the assets? So after are the assets then distributed after the creditors or before?
Right. You have to, first of all, make sure all the debts are paid.
Okay.
That's very important.
Yes.
Then after that, after all debts are paid, if ever it's possible,
Yes.
depending on the assets that are left behind and obviously of the amount of money that is left in the bank. And then all other things have to be distributed amongst family.
The remaining family.
Yes, and starting with the actual children that belong to the deceased person and the spouse, and also followed by the grandchildren, followed by any other blood relatives that are proven to be related to the person that are of interest. You can't just distribute to
To
someone
anybody.
who has no interest, even if they're related.
How does the church help with deceased estates? Does the church help? Is there any way that they can help?
Finding it from the biblical context, what I have seen is that there's a lot of examples in the Old Testament, but fewer. Actually, there's only one example that I'm thinking of in the New Testament that we even speak about estates, the prodigal son, where we had an issue of a father who had to distribute his estates before his death.
Yes.
Yes. The church has been so much not. There's a lot of debate anyway, let's say, about it. Other people even think it's unchristian to write a will. Other people think it's Christian. Around our churches, there's a discourse around that. But I believe that we should actually motivate the church to get people more involved and understand wills and testaments. That will greatly help. For now, I think it's so docile. The church is not much involved. Okay. Yes. I'm not thinking of any organization that is representing the people, ordinarily members, probably people that are at office level, yes, conference level, union level, probably because of them being assumedly employees, probably have that privilege. But members, I'm not thinking of any. Yes.
Dr. Sibanda, thank you so much for your time. Thank you so much for your insights, and thank you so much for giving us a glimpse into the world of wills and estates. It sounds very complicated, it sounds very involved, but it's not so difficult. I think that if you are preparing for eternity, you should at least be preparing for life here on earth. And I think that you should also be making the right decisions and formulating the right documentation for your families to be taken care of. I think you can consult with anybody that you desire, but make sure that your affairs are in order. If you're at least taking care of your salvation, you should be taking care of your life here on earth. Thank you very much for joining us. Till next time.